An attorney representing a corporation owes her loyalty to the company, not to its shareholders, officers, or employees. Trying to serve both a company and its owners presents a conflict of interest if their interests aren't aligned. Failing to acknowledge such conflicts sometimes leads to serious consequences, as a law firm facing malpractice allegations learned in Murphy and Demory versus Murphy. Daniel Murphy co-owned the lobbying firm Murphy and Demory. The law firm Pillsbury Madison and Sutro represented Murphy and Demory. The Pillsbury attorneys handling most of Murphy and Demory's work were Deanne Siemer, a partner, and Keith Mendelson, a senior associate up for partnership consideration. While still representing Murphy and Demory, Siemer agreed to also represent Murphy in an attempt to take control of Murphy and Demory or to form a new corporation to compete with the company. Murphy hoped to divert numerous Murphy and Demory employees and clients to his new venture. Siemer didn't obtain the company's consent to this dual representation following complete disclosure of the material facts. Pillsbury Jr. Associates raised concerns with senior attorneys that simultaneously representing Murphy and the company created a conflict of interest. The associates were sent to Siemer to resolve the issue. Siemer concluded there was no conflict because Murphy and the company shared an interest in Murphy having the best possible information about his options. On Murphy's behalf, Pillsbury took several steps adverse to Murphy and Demory's interests while continuing to represent the company. Pillsbury prepared a takeover proposal for Murphy and met with Murphy and Demory's director to solicit her support for Murphy's efforts. Pillsbury sought to induce Murphy and Demory employees to join Murphy's new company and help them to draft letters of resignation for Murphy and Demory. Pillsbury also drafted letters for Murphy and Demory's clients to use to end their relationship with Murphy and Demory and to request that their files be sent to Murphy's new business. Pillsbury organized and attended meetings with Murphy and Demory management and employees and used confidential information it gained at those meetings to help Murphy. Pillsbury didn't disclose to Murphy and Demory material information Pillsbury knew that might have affected the actions of Murphy and Demory's board. Eventually, Murphy and Demory fired Pillsbury. After being fired, Pillsbury filed a lawsuit, purportedly on Murphy and Demory's behalf, seeking judicial dissolution of the company and relying in part on confidential information obtained as company counsel. Murphy and Demory sued Pillsbury, Siemer, and Mendelson, alleging legal malpractice. Following a trial, the court issued its decision.